Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
On the second.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here,
Okay.
what your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it. File.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have.
Right out of the gate, this video is doing something important that most people miss. It shows you that sovereign citizen behavior isn't random stupidity. It's patterned self-destruction. Every person you're about to see genuinely believes they've discovered some legal cheat code. They think if they refuse to sign paperwork, deny jurisdiction, or declare themselves an American national, the system just stops working. But courts don't run on belief systems. They run on procedure. And what makes this compilation especially brutal is that several of these people were actually handed leniency, probation, deals, second chances. And instead of taking the lifeline, they set it on fire in real time. Keep that in mind as we start with Mr. Walker, because his case is the perfect example of how talking yourself into freedom is easy, but talking yourself right back into jail is even easier.
I don't know. It's just the city of Detroit versus Albert Hemmer Hicks Jr. Appearance for the record, please.
Elwood S. Ferry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
This exchange right here is where everything quietly goes wrong for Mr. Walker. Notice how the judge isn't hostile. She's not rushing him. She's trying to clean up a procedural mess that frankly shouldn't exist, because entering a felony plea without an attorney is already a massive red flag. And yet, instead of recognizing the danger he's in, Walker keeps wavering. I don't know if I need a lawyer. I'm not signing anything. Those aren't power moves. Those are self-inflicted wounds. Courts can't force help on you if you refuse it. And the moment he won't waive counsel or accept representation, the court's hands start to tighten. This is how sovereign-adjacent thinking ruins outcomes. Not by arguing law, but by refusing the very mechanisms that protect defendants. Probation wasn't his punishment. It was his escape hatch, and he never even showed up.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the offer in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No.
Here's the reality most defendants don't understand until it's too late. Probation is not freedom. It's conditional mercy. It's the court saying, we'll trust you, but don't make us regret it. And when you never report, that's not a technical mistake. That's a total rejection of the deal. Once probation is violated, the court doesn't revisit how nice it was before. That window slams shut. The judge doesn't need to debate ideology or intent. The violation speaks for itself. And now, instead of checking in with a probation officer, Walker's checking back into custody. This is the recurring theme you'll see all video long. Every single one of these defendants believes compliance equals surrender. But in court, compliance is often the only thing standing between you and incarceration.
Oh, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything here. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about that.
I don't even have a
I
license
thought about that.
law.
Listen, this whole
I have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Oh, okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or.
And then we get Albert Hicks, the type of sovereign citizen who doesn't just misunderstand the law, but actively tries to dominate the courtroom with volume and confidence. From the moment he says, "No one speaks on my behalf," he's signaling that this hearing isn't about resolution. It's about confrontation. This is performative defiance. He wants control. He wants to flip the power dynamic. But here's the problem. Courts don't negotiate authority. You don't declare yourself an attorney. You don't announce jurisdiction doesn't exist. Law licenses, court rules, and constitutions don't bend because someone is loud enough to demand it. And the judge sees exactly what this is. Not legal argument, but obstruction disguised as confidence.
You didn't answer my question, so I'm moving on. And I'm going to put you out. Or at least mute yourself. All right, let's do this and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP15, SP1442547, no, 12, and 3 SP 144-27651 and SP 500-872. I'm only dealing with those matters, and the officers are not here, so we're gonna make this easy. And now, what I don't appreciate is, you know, I thought about that comment that you made that last time. You know, basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay, so let's get that straight. This robe has nothing to do with me as a man. All right, I'm gonna dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, so bye.
This is where sovereign citizen rhetoric completely collapses under its own weight. You have no jurisdiction isn't a magic phrase. It's a legal claim that requires facts, filings, and actual law. When the judge says she is the assessor of jurisdiction, that's not arrogance. That's how courts function. Jurisdiction isn't voted on by the defendant. It's established by statute, geography, and subject matter. And watch how Hicks dodges every opportunity to put something in writing. Because once you file a motion, fantasy meets scrutiny. Oral chaos feels powerful. Paperwork does not. That's why sovereign arguments almost never survive past this stage. They rely on disruption, not substance.
I am man. The flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status, and so I ask you, ma'am, what is your name? What is your nationality, and what is your status?
I'm Judge Grant. I am a citizen, and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violate.
This is the judge reasserting the boundary, and it's a critical moment. Courtrooms are not debates. They are structured environments where speaking out of turn isn't passion, it's contempt. And the warning here isn't theatrical, it's procedural. Judges don't need to win arguments. They just need order. Once contempt enters the conversation, the defendant's leverage drops to zero. And notice something important. Even after all the disrespect, the judge still offers Hicks options. Deal or jury trial. That's due process in action. The system keeps functioning even when someone is trying to sabotage it.
Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the
Unless you
law.
want to enter a plea of guilty, today there'll be a plea of not guilty. I understand you are objecting.
Ma'am, I
to-
object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of American Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice